or the local committee. If the internal committee is not constituted for the or for some reason, if it is beyond the 10 members in the employment organization, of course there is no compulsion. Then the local committee is there. So even for that, this is true. There has to be a professional touch. And later, there is one more reason. There is one more reason. Because you need to, it doesn't say that there should be a reasoned order passed by this committee. But what the committee prepares is a report. So your report naturally will have to state the reasons. Otherwise, when it is being tested of its correctness, that is destined to fall. We all know that. So therefore, the preparation of the report is also a very solemn act. It needs experience, or at least it needs a professional touch. How come the professional touch can be impacted into this organization is, of course, a matter for deliberation. But that is very much felt. And thirdly, I'm focusing more on 4 points, basically. And the third point is, I know that 10 minutes time is there, I suppose. 10 minutes or 12 minutes? I think I may finish in 10 minutes.
12 minutes, sir. 12 minutes.
Okay, I think I may finish in 10 minutes. Now, in compensation, there is one wonderful mechanism that is there in the statute, as well as the rules. When you go through the statute, as well as, I am not quoting the rules or the statute as such. Anyway, there is a compensation provided under Section 11, Internal Complaints Committee. There is a compensation provided. Okay. How this compensation? If a compensation order, there are two methods. There are two methods wherein compensation can be ordered by an internal complaints committee. Well, you may ask whether it is fine to award compensation and close the matter forever. It's not like that. It's not like that. Compensation is another civil, a tortious remedy which has to be provided by the compliance committee. So again, if compensation has to be provided, that should be the parameters for awarding compensation that has also been stated in the statute, and therefore the committee has to be professionally oriented. I repeat that word, professionally oriented. So compensation is there. Suppose a case is registered. Suppose a criminal case is registered, prosecution goes on well, and it ends up in a conviction of the respondent, nobody else, of the respondent. That is very important. If that ends up in the prosecution ends up in conviction of the respondent, then under Section 11(2), the court can award a compensation. Of course, the court can, even now under Section 357 of the Code of Criminal Procedure, it can award compensation. But the statute makes it compulsory that compensation should be there. Well, that is well and good. The internal committee has got another right under Section 13(3)(1). Under Section 11. Under Section 13(3)(1), there is salary deduction possible. Salary deduction of the offender, of the offending employee, of the respondent, that is possible. So an amount can be raised after going through the parameters that is given in, I think it is in Section 15. Anyway, the parameters have been given. Those parameters will have to be looked into, and the internal committee will have to reach a decision that such and such amount should be the compensation. It may be payable in lump sum. It may be in installments even. So this they can order. Of course, ordering is well and good. How come you enforce it? Here is a very, very serious issue, I think there is a very serious. I do not find an answer. Please help me. That is what alone I can say. What I see is that this order of the compliance committee is not equated with that of a civil court decree. Well, had it been a civil court decree, every civil court should have enforced it. Would have enforced it. It's not given that power. But at the same time, it says that if a recommendation is being made to the employer, and if the employer is not in a position to deduct the salary as such, then it can pass an order directing him to pay such amount, either in lump sum or in installments, pay such amounts. This order is there. And also the committee alone, the committee can recommend it for it can send it to the district officer, who will see that it is recovered as though it is an area of land revenue. As we recover the fines of criminal courts under Section 421 of the CRPC, the same procedure will have to be complied with. this will that will go for I mean the revenue authorities will be doing it eventually.
Yeah.
Obviously, I'm sorry. The revenue authorities will be doing it obviously, but that is one action. The problem is that the statute recognizes it as enforceable. That is why it prescribes that attachment and all other purpose as though it is a land revenue that can be done. It prescribes like that, but at the same time, it doesn't give the power of a civil court declaration. So first thing, this is the scope of improvement for the statute. And then there is another option. There is another option. If there is non-implementation of any of the orders, then under section 18 you can appeal. An appeal is provided under section 18. You can appeal. Okay, well and good. Where you can appeal? This is another question. Where you can appeal? What it says is that if the service authorities if there is any court or tribunal constituted for the purpose of service authorities, we can have it enforced there. Here we don't have it. The service authorities are, as far as the tribunals are concerned, we don't have it. Then what is another option? Then if no such authority is prescribed, then you will have to go for the rules. You'll have to go for the rules. Go into the rules, and under I think the industrial employment under Rule 11, what it has constituted the authority under the Industrial Employment Standing Orders Act. This is it. So the problem is that if a victim gets an order of compensation, the victim cannot itself apply for having it realized as though it is a land revenue. It's for the internal committee. If the internal committee omits to do it, he is virtually helpless. How come he approaches this authority? What should be the parameter in which this authority should consider it? Whether this authority can consider this order, whether this authority can test its enforceability, these are all aspects left unanswered. These things are there. Of course, these are all matters for improvement as far as the statute is concerned. And then, when it comes to enforcement, Section 13(4), what does it say? The employer shall act upon. The employer shall act upon is the word. Act upon in every terms, it doesn't say. But there are many judicial precedents which have directed the employers to enforce it as such. There has been, but this particular question, to my knowledge, has not been agitated before a court of law, before the High Courts or the Supreme Court, and that point probably will have to be if in some case if some person agitates this question, obviously that question will have to be answered. If every word of the internal committee recommendation will have to be abided, is there any option for the employer not to act upon any part of the recommendation? These are all aspects which are not clearly answered by the statute. So in these aspects also, of course, much light can be thrown by way of amendments proposed. So with respect to the statute, the forensic analysis with respect to the statute enables me with these loopholes, which I present for deliberation before this August panel. With that, I may be permitted to retire. I'll join whenever a question arises. Thank you very much.
Thank you, sir. Thank you for your erudite presentation, particularly going into the crevices of this act. Perennial dilemma that is there as far as this act is concerned, particularly at the implementation level. I would say that even institutions working in the higher education level, along with that, even if it's an institution which is part and parcel of as a legal mechanisms, everywhere ICC matters are really problematic, because the way in which the matters that you have highlighted are of paramount significance. In ICCs are drawn into controversies, maybe because of so many ambiguities that are there in the legislations, in the legislation as well as its rules. And further that, the nuanced understanding of this particular law never happens in any institution. As in when a matter, the institution sees a matter, they will be in total doldrums. That's where we find several, they are in the midst of several controversies, particularly to whether to give a even-handed justice. That is one particular aspect, whether the victim is being given an opportunity of redressal, and if so, in what way this has to move. So many glaring instances you have pointed out. I think this demands a serious deliberation because it goes into the soul of this particular legislation. Thank you, sir, for highlighting. Let us hope that we will continue this deliberation. I don't know whether it is possible this day, but continuously we have to be mindful of these instances if we are to bring out plausible remedies out of this legislation. Next, I would invite Dr. John Varghese. I think it's always a matter of joy to and contentment to invite Dr. John Varghese, who is still, I believe, is an academic, who has translocated himself from the academic field to the judicial field and doing a commendable role as in the Judicial Academy, where judges are being made. So Dr. John Varghese would be highlighting on certain areas which certainly need a sort of interventions, I think. He's also hearing him in quite a few occasions. He has got a penchant to analyze things, that too in a very threadbare manner. So Dr. John Varghese, again, I would repeat that if you can confine it within 12 minutes, then that would have been very, very fine. Please.
Thank you, sir. It is always a privilege to be amongst persons, more than one persons whom I can how I can confidently tell that they are my mentors, including you, sir, and Kamlesh, sir, and other teachers of Government Law College who have been my colleagues, my senior colleagues, and students of Government Law College. And Kamlesh, sir, has very eruditely presented almost all facets of this law. So I will be just complimenting to what he has stated. My view about this particular piece of legislation is that this is a piece of legislation which has been, as Girishika sir rightly pointed out, this is a piece of legislation which was enacted after a long gap from the Vishaga judgment. But this was actually, in a way, intended to water down many of the aspects of Vishaga judgment, especially regarding the assistance to victims of the harassment by third-party sexual harassment by third parties, other than those who are in the workplace. This act does not provide for any such mechanism for assistance for third-party sexual victims of third-party sexual harassment. Moreover, if we can see the precedents that or the international conventions which form the basis of Vishaga judgment, like CEDAW, Declaration on the Elimination of Violence Against Women, Discrimination, Employment and Occupation Convention 1958. All these pieces of all these international documents focus on one thing, and that is a right of a woman to work in a discrimination-free environment. However, when we come to the POSH Act, it is focusing on an entirely different aspect, that is compensating the victim of sexual harassment. So ultimately, when after the inquiry, what can the Internal Complaints Committee do? It can recommend for action against the person who has committed the sexual harassment, as also to pay compensation to the victim. And there is another facet of it. Now, there are two types of committees envisaged in the Act. One is Internal Complaints Committee and the Local Complaints Committee. The Local Complaints Committee is with respect to a person who is employed in an unorganized sector. If you go through the wordings of this Act, it can be seen that regarding inquiry, section 11, if you go, section 11 provides that in case of a person who is an employee, of a respondent who is an employee, the inquiry has to be proceeded in accordance with the provisions of the service rule, or where no such rule exists, in such manner as may be prescribed. But in the case of a domestic worker, the only course open is to forward that complaint to the police. There is no provision. The provision to give compensation is only with respect to a person against whom an inquiry is envisaged. So far as a person who is not an employee, there is no question of giving compensation, because there is no inquiry, and there is no question of giving a recommendation for deduction from his salary. So for this type of victims, what is the remedy provided under that? The remedy is that the complaints committee will forward the complaint to the police station under section 509 to register a complaint under section 509. But what is section 509? It's a cognizable offense. The person, the aggrieved person, can directly go to the police station and register a complaint. There is no need of an intermediary like a local complaints committee for the purpose of forwarding such a complaint. And the only purpose that this procedure will do is to explain the delay that has occurred in preferring the complaint within a reasonable time. And after the complaint has been forwarded to the police station, the role of the complaints committee stops. There is no provision in the Act to provide assistance to prosecute. There is no provision in the Act, even in the case of an employee who is in whose case a clear cut provision is there for conducting of an inquiry and giving a report is there. There is no provision in the Act to ensure that she is given the right to work that is given as a right under this Act, as well as that is envisaged under the various conventions and in the Vishaga guidelines. So basically what happens is that this becomes a mechanism whereby employee, that is only that becomes the only purpose of the Act. Now another important aspect is pointed out by Girish Shankar sir. How many of us know this, that this Act is there until we were called upon to make a presentation, or we were called upon to deliberate about this particular provision? In many of the institutions, even though there is a provision that there is a requirement of a mandate, there is a mandatory requirement that internal complaints committee has to be formed. In many institutions, a paper committee will be formed. As Communists rightly point out, even the constitution of the committee would be in such a way that for the namesake there will be persons. The persons who are, there is no clear-cut guidelines as to who is a person who is competent to be a member, like a person who is a person having knowledge of law. Any person having knowledge of law can be any person who claims to be a LLB holder can be a member of the committee. But this committee is having the powers of a civil code, and in certain way the recommendations of this committee can be implemented in the manner of a criminal court order of compensation of fine. But the persons who are made members of the committee may not be competent enough to handle such matters. This will also create a problem. And another issue is, in many institutions, what happens is that only when a person is faced with a situation, she will inquire whether a committee exists, and then immediately somebody will be constituted as a committee on an ad hoc basis, because in paper there will be a committee, but the committee members might have got transferred or might have moved away from that institution long back. This is a practical scenario that is happening in many institutions. And when the person comes up with a grievance, for the purpose of handling that issue, a committee may be constituted from air, and that committee will be handling the issue. So, in fact, a sense of ad hocism is there in our approach to this to this law. Again, if we go to this particular provision regarding filing of complaint, now there is a clear-cut judgment of the Kerala High Court which says that unless there is a complaint in writing and the complaint is with respect to a sexual harassment, the complaints committee cannot take any action. Now, how is this complaint to be preferred? This complaint has to be preferred. The complainant has to take 6 copies of the complaint and give it to the internal complaints committee. Now, you expect this from a person who may be psychologically, not in a position even to complain. She may not be in a position to what you call, even orally come and give a complaint, but there is the requirement of the act and the rule says that 6 copies of the complaint has to be given to the internal complaints committee. And with what result? The complaint committee may inquire, and ultimately, sometimes if it is a if we take the case of a domestic worker or a person from an unorganized sector, the only role is to forward it to the police station under Section 509. And after the complaint has been forwarded to the employer, after the complaint has been forwarded to the police, or after the report has been submitted to the complaint to the employer, the role of the committee is over. The committee has no other role. Now, what there is no, as rightly pointed out by Kamini sir and even earlier speakers, there is no clear guideline as to what the employer should do with the report. There is, of course, the law says that the employer shall implement it. Now, how should the report be implemented? There is a provision which says that it can even be a written apology. A written apology can be accepted from the person and the matter can be closed. The other provisions are also there. That is the first thing. Written apology can be accepted and the matter can be closed. Will this actually, or will this in any way alleviate the trauma faced by the victim? That is something that we have to look into. I would suggest that apart from compensation, there is a requirement of, as rightly pointed out by Kamini sir, there is a requirement of relook into the provisions of the Act, especially with respect to the outcome of the inquiry. Now, after the inquiry, there are certain interim provisions like transferring the person or giving a safe place to the employee, to the complaint aggrieved person. But after the inquiry is over, after written apology is accepted by the employer, or after compensation is paid, what happens? What if for the purpose of inquiry, the person is even transferred to some other place and then he is brought back within a short time? There is no provision to handle such situations, and there is no provision to give assistance to victims in case they proceed with a complaint complaint to the police. So my suggestion with respect to such sort of activities is that there should be a I think Kerala State Legal Service Authority or district legal service committees can play an active role in providing a mechanism to assist the victims who intend to proceed with the legal remedies other than that is mentioned, other than closing the case by accepting compensation. For that, a panel of lawyers can be formed who can give proper legal aid to these victims. And there should also be provisions for counseling and restoration of confidence of the victims, who so that they'll be able to perform their activities at least in a manner, though some mental traumas cannot be compensated even by counseling or psychological interpretations. At least to a certain level, they can be restored to their normalcy. So these are my suggestions. I think the rest of the things can be considered at the time of discussions. Thank you, sir, and thank you all for giving me an opportunity.
Thank you, John. I'll reflect upon what you say at the fag end. Let us move on to Dr. Jayesh K. Joseph, criminologist, Kerala Police Academy, who needs no introduction in our academic circles and perfectly in legal circles as well. So please.